173401, John Doe versus Denison University. Arguments not to exceed 15 minutes per side. Mr. Rosenberg for the appellant.
You may. Thank you.
On behalf of John Doe, my name is Eric Rosenberg, and I thank you for this time. Judging from the comments of the court, I'll get straight to what I believe is the issue in this case, which is whether gender bias exists in a Title IX context, because we are not here to address whether there was a consensual sexual encounter between my client, John Doe, and his accuser, Jane Roe. The district court has found that there was a consensual encounter and that there was an erroneous expulsion, but the district court determined that there was not gender bias.
So are you you pursue 4 claims on appeal, it seems to me, claims, theories, whatever. One of them is erroneous outcome, but you also have others, including selective enforcement, hostile environment. And those claims, the district court also dismissed. Are you still pursuing those claims?
I am, Your Honor, because all 4 claims that you referred to are all hinging on whether gender bias exists. If gender bias exists, then potentially all 4 claims are viable.
How can that be? So what evidence do you have of a hostile environment?
The hostile environment would include the evidence to establish a gender bias. We have examples of, I'll be specific. So the adjudicator in this case, President Weinberg, he tells, shortly about the time of an OCR investigation, he publishes a letter that says that our blueprint for investigating sexual assault from now on is going to be with the culture of respect. And that culture of respect...
I thought all of that goes to, all that evidence that you're talking about, it seems to me, could arguably go to a pure gender bias claim of erroneous outcome. That you had an erroneous outcome and it's because of your gender. But a hostile environment, it has to be so severe or pervasive. I mean, how is that here in this case? There's no evidence from what I read in your complaint that your client was subjected to a hostile environment.
Well, the totality of the gender bias evidence, I would argue, does establish a gender, but I would like to move on from that issue because I can see where you're going and focus on what the gender bias evidence is on the remaining claims, which...
Well, the selective enforcement, yes. You didn't even plead in your complaint that I could find.
Actually, we did, Your Honor, in the context of a discrimination hostile environment claim. So we did not articulate it as a selective enforcement claim. You are correct.
Okay.
We said there was discrimination on the campus, and it was discrimination because when a female engaged in sexual misconduct, she was not disciplined. Only males were disciplined, so we said there was a discriminatory conduct in the
Do you have any evidence you pointed to of where a female engaged in sexual misconduct and was not disciplined?
And what we did was, because of FERPA, we can't get that information because this is a private university, so we pled upon information and belief that this was the occurrence that occurred, and we identified in the debriefs 5 different cases, district court cases, and including one from the Southern District, that said that you can use information and belief allegations to advance these types of claims because you can't identify the comparator in a situation where you can't, that takes discovery. So if I may get into the gender bias issues, which are critical here, the district court's dismissal was an error because it improperly construed dozens of pieces of gender bias evidence against John Doe with regard to the Twombly-Iqbal and cases similar.
You advocate in Twombly-Iqbal a minimal plausible inference standard that the Second Circuit came up with. But aren't we bound by the Supreme Court? And what is a minimal plausible inference? What's the difference between Iqbal and Twombly saying there has to be a reasonable or plausible inference and a minimal plausible inference?
Well, because the Columbia decision in the Second Circuit discusses that. What happens when you're applying Title VII case law into Title IX context, and what they're saying is that it's a reduced burden because what happens in the McDowell-Douglas shifting test is, during summary judgment, is the plaintiff articulates the reason, the school would articulate a legitimate reason, and then you show pretext. So it's a lower standard. But even if you do not go to Columbia, what we have is what would be, for example, we have the adjudicator, in this case, Ms. Hausman, who tells her fellow adjudicators that they need to consider the future of 1,000 girls
Did that happen before they determined guilt of your client or after?
The information is pled that she's telling that while they're in deliberations about what to do, that they have to figure out 1,000 girls in the future.
Before they determine his guilt?
Before their guilt.
I'm sorry to interrupt you again, and I apologize. I'll be quiet, I promise, after this. The district court seemed to pull each statement and make an inference. Is it your view that you take all the facts alleged together, draw inferences in your favor, and then see if there's sufficient evidence?
Absolutely, Your Honor. The totality under the Williams and General Motors case, which is a Title VII case, says you have to look at the totality of the evidence when making an evaluation. It's not a divide and conquer strategy where you look at individual pieces. But even if you looked at individual pieces with Hausman, I respectfully suggest that the district court would likely not have dismissed the case if my client were an African American accused of assaulting a Caucasian and the adjudicator wanted to put the future of 1,000 Caucasians in evaluating whether there should be discipline done.
What's the best case that you have that you're going on here?
The best case that we have would be the Second Circuit Columbia case, which is directly on point on this issue because it addresses an issue that the district court what they basically said was, look, John Doe shows that there's bias in favor of victims, and that's okay because a victim could be either a female or a male. Columbia directly addresses that issue by saying you can't make an inference that, even if it's a lawful inference, that you're trying to show deference to the complainant at the motion to dismiss stage. That is a summary judgment issue. So what we're happening, but even if you didn't apply that here, we have examples, another example of adjudicator, the president, Weinberg. He identifies the blueprint as this Culture of Respect website, and this Culture of Respect website says that Denison should produce skits that show men how they use physical and psychological coercion to rape the female actor. Now, if this were a race case, would we be here if you had you were linking yourself to an organization that said, no, I want you to show a skit that Hispanics somehow exhibit physical and psychological coercion to rape Caucasians? It's a different standard being applied. So we have really essentially direct evidence of gender discrimination pointing to the fact that the victim is a female, including, I might add, the connection that the court found between these Atixa and NICHRM groups. There's two groups that Denison's connected with. Those are their abbreviations. In fact, the investigator who investigated the case was an outside investigator affiliated with those two groups. Denison, and they actually have a white paper that says that we should deconstruct the due process castle that's been given to the accused in disciplinary proceedings to give more rights to the victims. And this group identifies the victim as a female.
So we read all those facts. Let me ask you a hypothetical. Should we, if all they were doing was saying we take sexual assault seriously, anyone accused of sexual assault we're going to suspend or expel? Doesn't matter. It's not a state university. It's a private university. Constitution doesn't apply. We're going to expel everyone. That'd be okay, right?
It would be, as long as you're identifying victim victim is a gender neutral term. At Denison, what we have here is multiple examples of victim equals female.
Well, so you start out in your complaint with the way Denison got involved in all this is a young woman who was sexually assaulted, filed a complaint. Denison did nothing about it, so she complained to the DOE or something to that effect. DOE comes in, and you assume that was male on female sexual assault. Is that a fair assumption?
Absolutely, Your Honor, because the facts, for multiple reasons. The complaint has many examples of citations about OCR going after universities for not disciplining men. But more importantly, the only gender-specific reference in the highly redacted OCR documents is one to a female complaining about a hostile environment because they did not discipline someone in the sexual harassment context. It can't be same-sex. Because
what can't be same-sex?
Because let's assume that we know a female complained. If she complained that she was being assaulted by a female, that would not be a Title IX proceeding because the university would have to discriminate against one gender or another. If, in other words, if it's a male on male or a female on female, to establish bias on the university, you have to show that they favored one gender over another. That's what makes it a Title IX proceeding.
You're saying that's the case we have here?
No, in
Not
order.
what we have here, this is a male who's accused of
Well, no, what we're,
assaulting a female, right?
yeah, what we're saying, Your Honor, is that this female falsely alleged that Denison was giving guys a free ride, and that's what we're alleging. But they were investigated because of that. They were investigated because a female had complained that a male had gotten away, males, because it's plural, had gotten away with it and created a hostile environment. What I'm saying, though, is that in order to have a jurisdictional hook for Title IX, you have to have gender bias, which means you have to show that there's a bias in favor or against a gender. And if you have same sex, you can't have bias.
Why not? I mean, I'm assimilating to cases like Onkale, where the Supreme Court has said that you can have gender bias in same-sex harassment, right? Supreme Court said that.
Yes, you can in that context, but this is a disciplinary proceeding where you're saying, what the complainant is saying, is that you, the university, are discriminating against me.
But she could say, you discriminate. If a male comes in and says, I was punched, you're going to take it seriously. But because I came in as a female and said I was harassed, it doesn't matter who my harasser is, but as a woman, you're discriminating against me.
And let's assume, strike my whole point, maybe I'm wrong. Let's just assume I'm wrong to get to your point. What the critical thing is, what we're doing is you're making inferences against my evidence at a motion to dismiss stage and not a summary judgment stage. I should be able to have depositions.
That seems to me you're better
to say, I want to see all the files to show, because if it turns out that Denison actually, this was a woman on male claim and they're saying that it wasn't, I should be able to determine that. You know, for the court to say that we don't know whether the complainant was a man or a woman is disingenuous, because the only reference in that document is to a woman complainant. And to suggest that it's a woman on woman goes against all the other evidence in our complaint, which talks about, no.
They don't have to look at the rest of your complaint. They have to look at the totality of the facts and then draw inferences in your favor.
That's correct, Your Honor.
And that's where you're really saying they erred. Not that they have to look at your complaint to figure out what inferences they should draw, but take the facts and then draw the inferences.
There's all I'm saying, Your Honor, because I'm summing up now. The issue is this, that all we're supposed to have to do at a motion to dismiss stage is show a plausible inference, even without Columbia, a plausible inference of gender bias. And we show plausible inferences on at least two adjudicators in this case, putting aside the rest of the information. Thank you, Your Honor.
Okay, thank you. Ms. McLaughlin?
Good morning, Your Honors. My name is Natalie McLaughlin, and I am here on behalf of Denison University. This case presents a critical issue for many universities who find themselves embroiled in federal litigation for the disciplinary decisions they make when students are alleged to have committed sexual assault on their campuses. Whatever decision a university makes when a student is accused of sexual assault, one of the parties is likely going to disagree with that result. In reviewing the case law, you'll see that universities are sued by the complaining party and the responding party, by male and by female.
Counsel, universities have a tough road to hoe, but what they can't do is discriminate, whether it's against whites, blacks, women, men. And this case is, I understand what you're saying. I understand all of that. I think we all get that. But at the end of the day, this is just a motion to dismiss. I mean, we can make this a Title IX. We can make it whatever you want. But it's a motion to dismiss. And it seems to me, and you tell me why I'm wrong, when I read the district court's very thorough opinion, what he did is he either took a fact, drew an inference, and did it fact by fact, rather than looking at the totality of the facts and drawing inferences in the plaintiff's favor. And let me use an example that your opposing counsel used. This 1,000 girls comment. Had it been a Black Lives Matter defendant who assaulted a white male, and they said, we have to take the safety of our 1,000 white students into account, we would lose our mind here. If you were up here trying to defend that comment, we would lose our mind. Why is this any different?
Sure. So Let me address that first, the Hausman comment. During adjudications, what occurred was, what's alleged to have occurred was that
We take that as true.
Right, and we take it as true for this. So Hausman comment was that panel members needed to weigh the future of 1,000 girls. We maintain that the only way to read this is it reflects consideration of the safety of other people who could be at risk if Doe is expelled.
So go back to your opposing counsel's hypothetical. You're saying that we could not say that the university was acting discriminatorily if they said we need to take into account the safety of 1,000 whites when you have a black defendant. You're telling me that this court could not say that that is evidence of discrimination.
Yes, I think you could in that case. I think that situation with white on black assumption is a different situation than what we have.
Why is it different?
Sure. So if Hausman had said during adjudications that we need to consider the future of 1,000 other Denison students, while we're deciding what penalty to impose on this person, okay, that would we be contending that that was discriminatory? That would be stating the same thing, though, whether she uses the word girls or doesn't use the word girls. By all accounts.
No, because then, okay, so if I have a black defendant or an Asian defendant, so I'll use my race, an Asian defendant, and I say we need to take a future of 1,000 white students because that Asian's bad, that to me seems to state a case for race discrimination. Whereas if we say we need to take into account the future of our students in our university because that person's violent, and we've already made a determination of guilt, because you have to make a determination of guilt before you take into account the future. But if you're taking into account the future before you've made a determination of guilt, you're prejudging the case because of the person's gender or the person's race.
So the claim is that this comment was made during the adjudication process in which the University Conduct Board is deciding, both guilt and the sanction.
Sure, and we draw the inference in their favor. And I'm just picking one fact out.
Sure, and if John Doe here, what we have is he's alleged to have sexually assaulted a female student. And there's no evidence in the record that indicates that he did anything that was...
But you've conceded for purposes of this motion that it's an erroneous outcome. Correct? You're just contesting whether it's because of gender.
That is correct.
Not that it is, but that they pled.
We are saying that at the motion to dismiss stage, taking the facts that's true, there are probably very rare situations in which there aren't sufficient facts to plausibly allege that the outcome itself was erroneous, but that the facts as alleged here there aren't sufficient allegations that are factual allegations to show that gender bias caused that erroneous outcome.
Can I ask you a factual question? I'm sorry to take an aside, and then I'm going to be quiet, but what happened to Man Bun?
What happened to Man Bun?
Did he get suspended? Was there any investigation? I mean, he committed a crime.
Sure.
Or allegedly.
Well, we do not have that evidence in the record as to what happened
you can
to
move.
Man Bun, but it is a great nickname for somebody. So I did want to, the point with Hausman's comment is that the student body, if she is believing that this is somebody, a male who has committed a sexual assault against a female, okay, and that's what they're deciding, did this male commit a sexual assault against a female? When she's deciding upon the sanction, what to do, is this person going to be suspended? Is it going to be expelled? What's the consequence if Denison gets it wrong? What's the consequence if they don't expel?
Counsel, she gets to say that comment in the sentencing, no problem. Every day I sentenced a child rapist, I thought about the future of other children, okay? But the problem is here is the inference is drawn in their favor. They say it's during the adjudication phase. If she's saying it in the guilt phase, completely different. Then that's a really problematic comment. When you couple that and take all of the facts alleged, and I get that they're alleged. This case might be kicked on summary judgment, but they're alleged. And you draw them in their favor, there's at least sufficient evidence, it seems to me, that if you take plausible inferences in their favor, to withstand a motion to dismiss. And tell me why there's not.
Well, in the record, the adjudication, as it's pled, there's not two separate proceedings.
Right, but we draw the inference in their favor. This is where the district court erred. They said there's one inference, there's another inference, at least it seems like to me, and I'm drawing the inference that seems more likely to me. That's not what the Supreme Court's told us to do.
We do not believe that comment, even if it's said during if it was a separate proceeding, if it's during the decision-making process as opposed to a sentencing process, it's still expressing, she's having adjudication discussions with her fellow panel members as to whether this person, is responsible and what they need to be thinking about. And the student body that's put at risk, if they allow him to, if they don't find him responsible, or if they allow him to remain on campus, the student body at risk is the female student population.
Can I ask you about that? Because that's where I struggle, and maybe I'm wrong, but if they don't find him responsible, that's like saying someone's not guilty of a crime of whatever, murder, but now everyone's at risk that this person's going to kill someone. I mean, that I'm struggling with that part of it. I get it if you find him responsible. It's your comment, if you don't find him responsible, you're still putting people at risk. How can that be?
Well, I think it's because the adjudication and the sanctioning process are one and the same. But let me move on to the other members.
Wait, but I want an answer to my question. So the answer is because they're the same and you've predetermined his guilt? I mean, you see what I'm saying? Am I making sense? I'm just struggling with, if you don't find him responsible, there's still potential victims out there. That's like, I mean, that is feeding into what the plaintiff's saying, which is the university's just out to get males.
Well, there are other members of the disciplinary panel, obviously, other than Hausman. There are other members who both found him guilty of sexual assault and then ultimately imposed the sanction they imposed. And Cummins indicates that it's well established that school disciplinary committees are entitled to a presumption of impartiality, absent a showing of actual bias. I mean, here, what we have, and I believe this is the only thing that even moves it close to the mark of plausibility, though I still do not believe it gets there, is this single comment by one person during the adjudications.
Does the plaintiff claim a bias on the part of one of the hearing officers? Is that what you're saying?
I'm sorry, what was that, Your Honor?
Is the plaintiff claiming a bias on the part of one of the hearing officers? That's just what you said.
Yes, he is claiming that one of the hearing officers made this comment and that it is reflective of bias. There is no contention that any of the other disciplinary committee members was biased. There's no contention that, remember, there's also a university appeals board that reviews this decision. And there are not any plausible factual allegations to indicate any member of that university appeals board was biased. And then there's a presidential review of that decision. And there are not any facts to plausibly indicate that the president was biased to find against this
All of those are
individual because
appeals,
he's
though,
male.
right? So if a district court's biased against someone, it doesn't matter if the next two reviews aren't biased, right? If the lowest level, the fact determiner is biased, that's a problem, right? I agree. I understand what you're saying. It's one of many, but I'm just saying if the fact determiner is biased, it's a problem. You don't have to. That doesn't get you out of the problem.
It is a problem, certainly in our court system, though I don't believe that universities should be held to the precise standards that a court system is held to. I mean, they are not...
No, I agree, but if this was a race discrimination case, it seems really easy to me, and that it just seems like if these comments were made with regards to a race discrimination case, we'd be yelling at you, right? I mean... And so how do we distinguish that? What do we do with that?
To me, I mean, the critical thing comes down to what was the student body at risk. The student body at risk by the behavior. This person, Hausman, is clearly decided that she believes he's guilty of sexual assault. I mean, she's having these communications with the other panel members, and she believes that he has committed sexual assault. After sitting through the hearing and hearing the testimony and hearing all the evidence, she didn't make this comment before the hearing, okay? This is a comment that she made after sitting there, and they're going to have their adjudication discussions. And I think to say that she couldn't make this comment expressing the importance that she felt of getting it right and the importance of what she thought the consequences would be if they didn't get it right. And the student body that's at risk are females.
That's a perfectly legitimate inference. It's just one that, should we be drawing it now? You can take her deposition. She can state her piece. If they don't have material issues of fact going the other way, you win at summary judgment. My question is, you've given us a perfectly legitimate inference. Should we draw it now? Or is our job to draw the inferences in favor of the plaintiff?
We do have to draw inferences in favor of the
You
plaintiff.
see why I'm saying this isn't, even though you want to talk about Title IX, you want to talk about the pressure the universities are under, at the end of the day, and I get all that, this comes down to a pleading case. Has the plaintiff sufficiently pled a claim? And this is where I'm struggling, and just tell me, even though you come up with perfectly logical arguments, if we draw the inferences in their favor, there seems to me some there. Tell me why I'm wrong.
We do not believe, even drawing the inference that this one, consider the future of 1,000 girls comment, that comment does not move us to a plausible conclusion that gender bias is what caused the expulsion here. I mean, we don't...
Would you say, I hate to keep bringing you back to this, would you make the same argument if it was consider the future of 1,000 whites?
No, I would not.
Okay.
And I do
appreciate
believe
your honesty.
that is a different situation.
Why?
Because when you're saying consider the future of 1,000 whites, we don't have a identified body that is at risk if the decision is wrong. The allegation here is sexual assault, okay? So if they don't make the right decision.
Sorry, I didn't follow you there. We don't have, if you have a black defendant, they're at risk. If you say consider the future of 1,000 whites, it seems to me that's bias against whoever your defendant is, black, Asian, Hispanic, whatever it is.
And perhaps if there is evidence of some sort of hate crime type issue that we could show that the only party that was at risk by this conduct was a particular racial group, that might change the circumstances there. But I mean, here we're dealing with sexual assault, and an alleged sexual assault, what they're considering is a male sexual assault on a female. And what is the body that's put at risk if we get that decision wrong? And who are the individuals who could be harmed if we don't expel this student? And there's no indication in the record that there's any risk to the male student population. The risk, if they get the decision wrong, if they don't expel the student and he indeed sexually assaulted a female, the risk is to the female student body. I don't, obviously...
Before your time runs out, Judge White, do you have a question?
Yeah. Was this comment, do you understand this comment as that 1,000 women would be at risk from this particular person? Or if we don't get these types of cases right, 1,000 women are at risk from an array of men?
The first, Your Honor. I don't believe that there's any indication that comment was made to relate to the second.
What is your best case? Your opponent says the case from Columbia is the best case. Do you have a circuit case?
Yes, I would say our best case is our Cummins case, which was decided by the Sixth Circuit.
Doe v. Cummins. That's
Doe v.
unpublished,
Cummins,
right?
Yes, but Cummins discusses, the Columbia case, and we're certainly not opposed to looking at the Columbia case too. We do think that is a significantly different factual pattern than here. Ultimately, can I close with one brief statement?
Yes. Thank you for asking.
Title IX does not provide every student who disputes a university's adjudication of sexual misconduct with a legal right to appeal that. And as Your Honors noted, what we're trying to get at is whether there's been a plausible showing that sex discrimination caused the determination in this case. We think here that when we're looking at the non-conclusory factual allegations of the amended complaint, they aren't sufficient to plausibly infer that Denison's expulsion of Doe was because of his gender. And therefore, we maintain that we should affirm the district court's decision.
Thank you, counsel. That was a long sentence, by the way.
Thank you, Your Honor.
Before you start, Judge White, do you have any questions for the plaintiff?
No.
Okay, go ahead, sir.
To reference one of the defenses raised by Denison was this argument about that there's a presumption of honesty or impartiality. And the issue that they're referring to a case, it's the Atria, I'm not sure it's that pronounced case. That was actually a summary judgment decision, not a motion to dismiss case. There is a case, Murray versus New York University College of Dentistry, which talks about that. But even within the context of the Atria case, you get there's that inference is only applied absent showing a bias. And there was a kind of a mistake in the facts that was just described, that there was no reference of the president holding any bias. That's incorrect. The president was the one who put up the blueprint that I'm going to endorse here is the blueprint that it requires or suggests skits that men be shown using their physical and psychological coercion to rape the female actor. So there's example of some bias going on in that context. And the most important, in addition, I guess I should say, it's the president who is aligning himself with the groups Atixa and Neckerm, which I mentioned earlier, and that was the group that wrote the white paper that said that victims are typically women.
But just because someone writes, I guess I worry about the ramifications of that inference, that just because you align with an issue-oriented organization, you immediately become biased.
And what we're doing is it's the totality versus, you're looking at pieces. And so if the university is going to align itself to an organization that advocates the stripping of due process rights from African Americans so Caucasians could get more rights, you would have a similar concern that you're connecting with the group with a radical position contrary to American jurisprudence. So it's not, now we could be completely wrong. My client could go take a deposition and find out that there isn't a connection, but Denison aligned themselves with these three organizations. There's no dispute. And even the district court found that the taint of Neckerm on the investigator was enough to establish gender bias. The totality, all I'm saying, Your Honor, is what we need to be looking at. If I were to be asking this court for one thing in particular, it's that when we look at Title IX, we look at it in the context of the totality of evidence and not in the divide and conquer, because that's what Title VII would do, and that's what should happen here. Thank you, Your Honor.
Thank you. Judge White, anything further?
No.
Okay, thank you both very much. I appreciate you, we all appreciate your thoughtful arguments. The cases will be submitted.